Hi, morning.
Yes. Morning.
You're from African Investment.
Yes,
Would you mind going around and sitting that side? Hi,
Okay.
how are you? Hi. 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 Take a seat. Right, morning everyone, and welcome. I'm John Band. I believe I am your agreed arbitrator. People usually refer to me either as Mr. Brand or Mr. Arbitrator. But before we get into the arbitration itself, can I just click on the question of language? My working language is English. Are we going to need any interpretation if we proceed primarily in English?
Thank you.
No, we're not needing.
Both sides. Right. I'm going to be recording the proceedings, and if at the end of the proceedings there's a need for a transcript, that can be arranged. Right, can I just check who are the parties to the arbitration?
Mr. Arbitrator, my name is Ingrid de Villiers. I'll be speaking on behalf of African Investments. With me will be Mr. Jerry Karpu, who is Ms. Fulton's immediate supervisor. He'll also be giving evidence in these proceedings.
Right, thanks. And from the employee side?
The employee's name is Karen Fulton. My name is Joe Bayebi, and will be representing the employee in these proceedings.
Thanks very much to both of you. Can I just ask you to complete the attendance register so that I've got a formal record of who is in the arbitration? And can we also just check on times? The arbitration is scheduled to continue until 5 this afternoon. So can I just check with both of you that we can have 5 as cut-off time?
Yes, that's in order, Mr. Arbitrator. Thank you.
That's in order for us, Mr. Arbitrator.
And what I'd like to suggest is that we take a lunch break about 1 o'clock. But if we can confine it to 30 minutes, I find that we can usually get through lunch in that time, if that's okay with you.
Yes, thank you.
Is that
Will be fine with us.
Okay, and then as to tea breaks, I'd like to suggest we take a 15-minute tea break sometime halfway through the morning and halfway through the afternoon. But let's not fix a time now. Let's just see what would be convenient to all of us at the time.
Yes, thank you.
Is that
That will be fine.
Right. And I see this is a non-smoking venue, so can we just agree that we won't smoke here? We'll take breaks from time to time, and if people do need to smoke, they can do it then, if that's okay. And then also, can we just agree to switch our cells off? I'm going to just switch mine off, and if we can, just try and avoid interruptions of any sort, if that's in order with both of you.
Yes, thank you.
All right, is there anything else that we need to deal with by way of housekeeping and introduction before we get into the arbitration itself? Thanks. All in order.
Thank you.
All in order.
All right, can I just check with you, have you signed an arbitration agreement? Is there a signed arbitration
Yes,
agreement?
Mr. Arbitrator, it is the standard arbitration agreement, and my colleague, Mr. Bayepi, has already signed it as well.
So it has been signed.
It has been
by both
signed.
parties. Can you just give me a moment to just take a look at it? Yes, I see it is the standard IMSA arbitration agreement. Is that correct?
That is correct.
And
Yes.
there's nothing particular that you need to draw to my attention about it?
Not at this stage.
Okay. I'd like to just explain to you the procedure that I'd like to follow in the arbitration. What I'd like to start with is to invite first you, Mr. de Villiers, to give a brief opening statement in which you give me the essence of what the company's case is. And then, Mr. Bayepi, I'd like you to respond and give me your opening statement. And in that, again, just give me the essence of what the employee's case is. And then what I'd like to do is to try and help both of you narrow down the issues and try and determine what is not in dispute between the two of you and what is in dispute, so that we can try both to truncate the proceedings as much as we can, but also to make sure that we focus at the evidence stage on the issues that are really in dispute between you. So once I've done that, what I'd like to do is to just briefly explain to you what rules of evidence I will be applying in the arbitration, and then we can get on with actually hearing the evidence itself. And the way I'd like to do that is to usually the employer leads its evidence first. There may be a variation to that depending on what the issues turn out to be, but assuming that is so, I'd like you to call all of your witnesses They will go around, sit in the witness chair down at the bottom end of the room there, and then I will give you an opportunity to examine your witnesses without any interruption from Mr. Baepi, and you must ask all the questions you want of your witness at that time. And then, Mr. Baepi, when Mr. Villiers has done that, I'll give you an opportunity to cross-question the company's witnesses, and you'll have an opportunity to ask all the questions you want of the company's witnesses. When that's done, you'll have a last opportunity to re-examine the witness. When we get to that stage, I'll give you some more do's and don'ts of examination and cross-examination and re-examination. And then you'll call your next witness, and we'll follow the same procedure until all the company's witnesses have been called. And then, Mr. Baepi, it'll be your turn to call the employees' witnesses, and we'll follow the same procedure. You will examine, Mr. Villiers will cross-examine, and then you will have a last opportunity to re-examine the witness. And then when we've called all of the witnesses, what I'd then like to do is to invite both of you to address me in argument as to why I should rule in your favour based on the evidence that we have heard. And it's conventional for you to have the opportunity to do that first if you've led your evidence first, and then I'll call upon you, and then you'll have one last opportunity to reply to what Mr. Baepi has said. Then once both of you have presented a closing argument to me, I will obviously go away and consider my award and then make it available to you within 14 days of the close of the hearing.
Yes.
Is that clear to both of you?
Yes,
That's
thank
clear
you.
to me. Thanks.
And please feel free at any stage during the proceedings, if you are unclear about a process or procedure, don't hesitate to just stop and check things out, and I'll help you as you go along.
Thank you.
Right, well then, what I would like to do is to invite you, Mr. Villiers, to give me your opening statement. If you could be as succinct as possible, just give me the essence of what the company's case is.
Yes.
Right.
Thank you, Mr. Arbitrator. Mr. Arbitrator, the company's case is a fairly simple and clear one. We have a disciplinary code which regards absence without justification as serious misconduct. We also regard failure to notify the company before or during the absence as a misconduct as well. The nature of our business is essentially in the banking sector. We need continuity of inputting of data, which is the position held by the employee party in this matter, and we feel that this rule, if you like, is justified. From the 6th to the 11th of September, Ms. Fulton, who is employed as a data capturer in the administration department, was absent from work. It was a period of 6 days. To date, we have no proof of justification. There are allegations which amount to justification, but nothing more than that. The company still has not had any proof as to the reasons why she alleges that she was compelled to stay away from work on those days. Regarding the second aspect, there are two aspects here. One is the absence itself. The other is the failure by Ms. Fulton to notify the company on any one of the 6 days. You will be hearing evidence from Mr. Karpu to that effect. And that basically is the essence of the company's case. Having considered mitigating factors and aggravating factors, after a proper and fair hearing, the company decided to terminate Ms. Fulton's services with the company on the 15th of October this year. And that is the essence of the company's case.
Right, thanks very much, Mr. Villiers. Mr. Bebe, could I now have your opening statement and reply to what Mr. Villiers has said?
Thank you, Mr. Arbitrator. The case of the employee is as follows: that she was indeed absent for a period of 6 days, from the 6th to the 11th of September. But as it would appear from our evidence, the absence was not without justification. It is also true that the employee failed to notify the company before or during her absence. But as it would appear from the evidence that would be led in mitigation, it was impossible for the employee to notify the company at the time. It is not the employee's case that the rule is not fair or justified. So we concede that the rule exists, it is fair, and that it is consistently applied. What we do dispute, however, is that there was no justification for the employee's absence. Finally, there is also a point regarding the procedure of the disciplinary hearing. It will become clear from the evidence that we will lead that the chairperson of the disciplinary inquiry was not independent, and that, in short, is the case of the employee in this matter.
Right. And what is your attitude to that allegation, Mr. Bebe?
Mr. Arbitrator, look, the inquiry was held some time ago. This issue was raised in the conciliation for the first time. Our attitude is the following: is that we believe that the onus of proof is on the employee party to prove that, in fact, this conversation took place. We don't recall the conversation taking place, and I'm prepared to go into the witness chair and give evidence in that regard. In the event of your finding that a conversation did take place, our attitude would be, and again I would have to lead evidence on this, that we're a fairly small company. The chairperson of the hearing is also an employee of the company, and that if a conversation did take place, it would have been about some other matter relating to the company's business.
Can I just check what emerges from that? Just if we can deal with the absence without justification rule first. It seems to me from what I'm hearing that there is no dispute that there is a rule in existence concerning absence without justification.
Correct.
And that rule was known and legitimate. You're not disputing that.
Correct.
And that it was consistently applied.
Correct.
And if I'm understanding both of you correctly, there's also no dispute that the employee was absent between the 6th and the 11th of September. That is not in dispute. What is in dispute is whether or not the absence was justified.
Yes.
Is that correct?
Yes.
All right. If I can just then turn to the failure to notify allegation. Again, what I understand there from you, Mr. Bebe, that the employee is not going to be disputing that there is a rule in existence.
That is correct.
And that the rule was known.
Correct.
And that it was legitimate.
Correct.
And consistently applied.
Correct.
And just help me, am I correct in understanding that you are not disputing that the employee did not notify the company?
That is not disputed.
But you are saying that there was justification for that?
For the failure, yes.
And are you going to be saying that there was in fact a breach of the rule, and I should take into account the explanation for the lack of justification by way of sanction, or are you disputing that there was a breach of the rule?
We will not dispute on instructions, Mr. Arbitrator. We will not dispute the breach of the rule.
Right.
We will have, however, would like an opportunity to present evidence and argument in mitigation.
Right. And I assume, Mr. Villiers, that you will be wanting to lead evidence concerning sanction as well by way of aggravation.
My understanding is that on the second charge, the only issue is whether the sanction of dismissal was appropriate.
Right. All right. Well, that I think I understand. I'll come back and I'll summarize this for you in a moment. But can we just go on to the procedural fairness situation? And I understand there that, Mr. Beepi, you are challenging the procedural fairness of the dismissal as well, on the basis, as I understand it, that there was a conversation between the management representative and the chair of the disciplinary inquiry during that inquiry. Is that correct?
That is correct. During the lunch break that we took during the inquiry.
Right. And what is your attitude to that allegation?
Essentially, our attitude is that the onus rests on the employee to prove, first of all, that the conversation took place, and that if it did take place, that the substance of the conversation went to the issues in the inquiry.
Right. So, as I understand the issue in relation to procedural fairness, there seem to be two alternative positions there. In the first instance, you are denying the conversation, and so you putting the employee to the proof of that. And in the alternative, you're saying if a conversation did take place, it was not one which in any way prejudiced the hearing, and therefore there was no procedural unfairness.
Yes.
Okay. Can I just check with you, Mr. Beepi, do you have any other procedural complaints, or is that your only procedural complaint?
No, that is our only procedural complaint.
Both in relation to the initial hearing and the appeal?
Yes.
All right, well, let's see where that leaves us. If we can just go back to the absence without justification situation, it seems there that there is really only one thing in dispute between the two of you, and that is whether the child was sick and whether it was necessary for the employee to be with the child, and whether that amounts to justification in the circumstances.
Yes.
But there's no dispute about existence of the rule, knowledge of the rule, legitimacy of the rule, consistent application of the rule. And you appreciate, therefore, that it's not necessary for you to lead any evidence on those issues. All I need to hear evidence on is on this question of justification.
That is correct.
It would also seem to me that as you have that information in your hands, that possibly you should commence leading evidence on that issue.
I'm fine with that.
And you'd be happy with that?
I think that would be appropriate. As I say, we don't know what the case is.
Right. Let's turn then to the issue of absence without notification. And again, there it seems that there is really only one matter in dispute between the two of you, and that is what is the appropriateness of the sanction for that breach. But there isn't any dispute that there was a rule in existence, that it was known, that it was legitimate, that it was consistently applied, and it's also not in dispute that the rule was breached.
Yes.
The only question which I have to decide is what is the appropriateness of the sanction for that breach. Is that correct?
Yes.
And there, all I need is evidence basically from you as to why dismissal is the appropriate sanction, and from you, Mr. Baepi, as to why you say that dismissal is not the appropriate sanction for that breach. I don't need any other evidence on that issue. And then the last issue in dispute is the issue of procedural fairness.
Yes.
And I'm going to have to hear evidence on this alleged conversation.
Yes.
But otherwise, there are no procedural disputes.
That is correct.
All right, well, I would appeal to both of you to confine both your evidence and your argument to those issues so that we can get through this arbitration by lunchtime.
Excellent. Thank you, Mr. Arbitrator.
Right. Well, before we get into the evidence itself, I'd like to just briefly explain to you a number of rules of evidence that I would like us to abide by in the course of this arbitration. And the first one is to just emphasize to you that if you wish me to rely on any fact, it's important that that fact must come out of the mouth of a witness sitting in the witness chair or must have been admitted by your opponent. So, for example, if you are going to dispute that there was this conversation, it's not going to be good enough for you to merely state that from where you are sitting here. It's going to be necessary for you to go down, sit in the witness chair, and subject yourself to cross-examination by Mr.
Yes, of course, I understand that.
The other point I just want to emphasize is that you carry the burden of persuading me that this dismissal has been fair. And if at the end of the arbitration I'm left in doubt, I'm going to be ruling in favour of the employee, and you just need to bear that burden in mind as we proceed through the arbitration. Yes. The other point I want to draw to your attention is that I'm going to give much greater weight to direct evidence, that is, evidence which a person has first-hand knowledge of, rather than indirect evidence, which is evidence which a person has been told and that person then relays to me. Then there's another point that I just want to draw to your attention, and it concerns documents. I just want to emphasize that documents don't speak for themselves. If your opponent in any way objects to the document, they will only speak for themselves if your opponent admits the document. If there is a dispute either about what the document purports to be or about its content, then you are going to have to call a witness to speak to the document. Is that clear to both of you?
Yes.
And then finally, I'd like to just draw to your attention that if you have any objection to your opponent leading hearsay evidence, indirect evidence, or leading evidence that is irrelevant or repetitive, then just indicate to me that you have an objection to that, and I will hear the objection and deal with it. Right. Then finally, before we get to actually hearing evidence, I just want to make a point about the presence of witnesses in this hearing. I've been quite happy to have witnesses and observers in the hearing up until this stage. But what I'd like to suggest to you is that when it comes to the time that you are going to actually call your witnesses, that if we're starting with you, Mr. Villiers, that you excuse all of your witnesses from the room and let your first witness come in, give evidence. That witness then can stay in the room and listen to the next witness and so forth. And obviously, while the company's witnesses are giving evidence, there's no problem with your witnesses being present to hear that. But again, when we get to the stage where it's time for your witnesses to give evidence, I'd suggest again that you excuse your witnesses from the room and let them come in, give their evidence, and then they may stay. And obviously, during that evidence, your witnesses can be present. I will just give greater weight to the evidence of witnesses who have not heard what the witness before them has said.
That is fine.
Yes,
all right, and I'll just remind you of that when we get to that stage.
Understand.
All right. Are those matters of procedure and evidence clear to both
Yes.
of you? And could we now move to the evidence stage?
Yes, thank you, Mr. Arbitrator.
Right, Mr. Villiers, Mr. Beepi has now called all of his witnesses, and it's your turn to call yours. Are you ready to call your first witness?
Yes, thank you, Mr. Arbitrator. My first witness will be Mr. Jerry Karpu.
Right, well, if Mr. Karpu could just go around and get into the witness chair, and then I can swear him in.
Thank you.
Mr. Villiers, you're not wanting a break now. You're happy for us to go straight into Mr. Karpu's
we can
evidence?
continue. I think so. Given the time constraints, I think we should keep going.
Okay, fine. Right. Can I just check with you? You are going to be giving your evidence in English, is that correct?
Yes, Mr.
Right. Can I just, for the record, have your full names, please?
My name is Jerry Kapu.
Mr. Kapu, do you have any objection to taking the oath?
No.
Right. Well, then, would you please swear that the evidence you're about to give in this arbitration will be the truth, the whole truth, and nothing but the truth? Raise your right hand and say, so help me God.
So help me God.
Right. Mr. Willis, you can examine Mr. Kapu.
Thank you, Mr. Arbitrator. Mr. Kapu, first of all, thank you for agreeing to give evidence in these proceedings. Can we start off by your just telling the arbitrator what your position is in the company?
My position in the company is I am the supervisor in the administration department.
And who falls under your jurisdiction in that department?
Well, the employee party, Ms. Fulton, and 10 other employees fall under my jurisdiction.
Yes. Thank you. How long have you been employed by African Investments?
I've been employed by African Investments for 5 years now.
Thank you. Now, Mr. Kapu, it's not disputed and it's common cause in these proceedings that Ms. Fulton was absent from work from the 6th to the 11th of September this year.
Yes, that's correct.
And she has also admitted that she didn't notify the company that she was going to be absent for these 6 days.
Yes, that's correct.
All right. Now, Mr. Kapu, could you explain to the arbitrator what is the company's attitude towards people who fail to notify the company?
Well, the company takes the absence without justification and absence without notifying the company as a very serious offense.
Thank you. And can you tell us why it's regarded by the company as being a serious offense?
We have had several difficulties in the past with regard to absenteeism. And what we have noted was that when employees don't report for duty without notification and without justification, I mean, it has an impact of disrupting our operations. And we have a difficulty also of arranging stand-in employees for those employees who are absent. We will prefer, and in actual fact, I mean, that is the most recommendable way that employees should notify the company of their absence or anticipated absence in due course.
Good. Thank you. And could you also tell the arbitrator what steps the company took to make sure that the employees knew about the company's attitude?
Well, upon realizing that this absenteeism problem is spreading all over and is becoming a big problem, we held several briefings, and the last briefing that we had was a week prior to Ms. Fulton's incident. In that briefing, all employees were present, that is including Ms. Fulton. They were advised that being absent without justification and furthermore without notifying the company is a very serious offense, and they were urged not to do that in the future, as that might jeopardize their careers within the company.
Right. Thank you.
Are you ready to start with your cross-examination, Mr. Baby?
Yes, indeed.
Right, well then if you could go ahead, please.
Mr. Kapu, I'd like to ask you a few questions about why you say that the failure to notify the company of absence is such a serious offense. It is correct, isn't it, that the company has two rules, one dealing with absence without justification and another dealing with absence without notifying the company.
Yes, that's correct.
Doesn't that mean that the company consider the two acts of misconduct as distinct acts of misconduct?
Yes, that's true.
Doesn't that also mean that, generally speaking, the company treats absence without justification more seriously than it would absence without notifying?
Yes, that's true.
And further, that it seldom dismisses people who fail to notify the company of their absence.
Yes.
Well, doesn't that indicate that it is unfair in this case to dismiss the employee for absence for not notifying the company?
No, in this instance, the employees, and that reference also includes Ms. Fulton, were briefed about the seriousness of being absent without justification, or for that matter, not notifying the company of their absence, and that those offenses are very serious.
Mr. Kapu, are you saying that it is normal practice for the company to dismiss employees who, having been absent, fail to notify the company?
Yes.
Are you also saying that of the employees who attended the briefing, those who breached this rule have been dismissed?
Yes, that's correct.
Are you absolutely sure of that, Mr. Kapu?
I'm absolutely sure about it.
Well, Mr. Kapu, we want to put it to you that of all the employees who attended the brief, who subsequently breached this rule, Ms. Fulton is the only one who was dismissed by the company.
I dispute that.
Mr. Arbitrator, I really must object at this point.
You want to raise a formal objection?
Yes, I really must.
Right, now if I'll give you an opportunity to do that, and then obviously, Mr. Bepi, I'll give you a chance to answer Mr. Villiers' objection, and then I'll give you a last chance to reply. So tell me what the essence of your objection is.
Mr. Arbitrator, this is the first time in all the proceedings, the inquiry, the mediation, and the arbitration, that this issue about inconsistency of sanction has been raised. And the company's severely prejudiced by the way in which it's been introduced and the manner in which it's been introduced. And I really think it's not fair to the company to allow this evidence to be introduced in this way.
Right. Mr. Bepi, what do you say to Mr. Villiers' objection?
Thank you, Mr. Arbitrator. I must firstly apologize for raising the issue of inconsistent sanctions the way we did. This issue was honestly overlooked when the issues were being narrowed, and I think that followed from the confusion with the consistent application of the rule. We were aware of these other cases that whoever did not notify was indeed disciplined. It is the outcome of the discipline that varied, and insofar as that is concerned, it is knowledge readily available to the company. In fact, in the possession of the company, we don't see any prejudice that the company may suffer in the way we have raised this issue. We do, however, are not taking these proceedings for granted, and we apologize insofar as that can remedy this situation.
Thanks, Mr.
Thank you.
Is there anything that you'd like to say in reply, Mr.
Well, obviously, look up, if an employee party is able to prove the allegations that are being made, it is important to their case. But by the same token, we will need an opportunity to investigate the allegations that are now being made. We'd have to know who the employees are who have been treated in a different way, and we'll need an opportunity, possibly even a postponement, to allow us to do that. And as long as our rights are reserved in this regard, and obviously because we want to expedite the matter, we would then be prepared to let it go, but with that proviso.
Well, certainly, Mr. Villiers, I'd be happy to and sympathetic to grant you any postponement that you need in order to prevent you suffering any prejudice in this matter. And on that basis, I'd like to propose that we continue with this
Yes.
evidence.
Yes.
Is that acceptable to
Yes,
you?
it is, and it is on record. Good. All right, thank you. Then we may proceed.
Right.